Thank you.
Good morning.
Good morning.
Winfrida Mokaya, Chief Registrar. You're welcome.
Thank you.
Yes, thank you, Commissioners, for that introduction. Mrs. Makori, if you could start by telling us your county and your ethnicity.
My county, eh?
Your county.
Thank you, Honorable Chief Justice. My county is Nyamira.
Your ethnicity?
Kikuyu.
Kikuyu. You know why we ask those questions?
Having served as a state officer, I believe they are important because there is need for inclusivity.
If you can put the mic right at your mouth so that everybody can hear, including the media, who are interested in following these proceedings.
Thank you once again. Can I be heard? I believe they're important. In my past life, I've served as a state officer, and I know it's important to comply with Article 10 on inclusivity. Maybe Article 27 on non-discrimination, and regional representation.
Very well. It's because of regional representation. Now, we will start this interview, but we like to assure our candidates to relax and feel comfortable. Although it's an interview, we like to have a very good conversation with you. We want to get the very best out of you, so please relax. And we will start because we want to know who is CS and Waceke Makori. What experience, skills, or knowledge do you intend to bring to the Supreme Court?
Thank you once again, Honorable CJ. CS Ann Makori has many roles. One, as a family person. I'm a wife to a gentleman by the name Paul Makori. I'm a mother to 4 adult children. None of them is below the age of 18. I'm a community member. I'm a Christian by faith. And I serve in my church. I serve in my community. So that's my personal life. I'm a professional. I'm a lawyer by training, an advocate of over 30 years standing. I've also trained in, other than LLB, University of Nairobi. I have a master's of Arts in Leadership, Business and Entrepreneurship option. I'm also a very well-trained HR practitioner. I have a postgraduate diploma in Human Resource Management. I'm a certified human resource practitioner. I'm a certified public secretary, certified mediator, and certified trainer. In terms of skills, have wide experience in work. I started my career as a young civil servant straight from college. I was employed by Public Service Commission as a state law officer, but the first batch of lawyers that was sent to support the Ministry of Labor back then and the Industrial Court, which was at the time under the Ministry of Labor. So my initial engagement was as a labor officer, mainly handling industrial relations. Job I did for my past almost 6 years. And that experience exposed me to the field of labor systems in Kenya, the trapeism, the trade unions, the employer organization, and the government being the neutral party, and gave me wide experience in mediation, conciliations mainly, and CBA negotiations. And I believe I was part of the team that contributed a lot to the reports that supported the industrial code back in the day. I then moved from there and worked for ART, which was a hire purchase company and a fully owned subsidiary of ICDC. From there, I moved out of what I would call government, ventured into private sector, and went into banking. Worked shortly in mainstream bank, then moved to media, where I served for a number of years, and I grew to become the head of legal and human resource for the Standard Group. And while there, was part of the team that led in the transformation of the Standard from East African Standard to the Standard Group, and I was responsible for helping them put structures in the legal department, the HR structures, and that began my life in corporate governance. Then I was later to move to Faulu, where I worked again in banking, but microfinance, regulated environment. That gave me exposure to regulated environment under the central bank, and the exposure to the economic realities at the bottom of the pyramid. I then moved to private practice for a short stint, then joined government again as the chair of IPOA. And that gave me exposure to the environment of accountability, human rights, and institutional governance. At Faulu, I was a general manager in charge of 3 functions: legal, human resource.
I think that is enough scope of the area of your experience.
Thank you. Mm-hmm.
We want you to locate those skills and experiences to the 4 jurisdictions that are exercised by the Supreme Court. How are you going to bring that experience to bear to the nature of the cases that fall within the jurisdiction of the Supreme Court?
Thank you once again, Honorable CJ. The jurisdiction of Supreme Court is anchored in Article 163. Under 163(1), presidential petitions following declaration of presidential elections, that's an original jurisdiction. My experience in fact is, even though I've not handled a presidential petition, I've worked within communities. I serve in communities in other organizations. And therefore I engage a lot with communities and would be able to explain to the communities, if need be. A lot of the people on the ground don't understand how the courts work, and that's why you'll find a lot of emotions around the decisions of the court. So would be able to participate in doing outreach even before the electioneering period. Within the structures, of course, I realized judiciary has started doing dialogues, having held one, I think the first one last year. So within the structures that can allow me to do that, I would be able to do that. And of course, as a judge, participate in constitutional interpretation and in dispensing the issues. I'm aware there have been 3 petitions, all of them with different learnings, and therefore I would also benefit from that. Supreme Court works as a college of judges, so I would not be alone. I'll be able to participate in that. The other role is hearing the appeals from the Court of Appeal and also from tribunals, depending on whether there is legislation to that effect. Another 163(4) as a right from Court of Appeal, and any matter that is certified of public importance. I've worked in IPOA, the area of accountability, human rights, and therefore I have a lot of experience in issues to do with human rights and accountability. And all this experience really has given me very good grounding in governance. The other area is advisory. Though limited, I've worked in government, I understand how government works, so I would be a valuable asset in areas to do with advisory, even if it touches on county governments. Having worked in a national government entity, you can't work without devolving the services that we carried out, and therefore we had offices at IPOA in all counties, and therefore I understand the devolved structure and the need to devolve the services further. The other area is state of emergency. Don't have experience on that. I would be looking forward to learning.
Very well. We'll move to the next area of the interview, and Justice Ishale will take it on from there.
Thank you very much, Honorable Chief Justice. Mrs. Makori.
Yes, my lady.
The records held by us at the Judicial Service Commission show that you have applied for different roles, albeit at different times at the judiciary. There is a time when you applied to become the Deputy Chief Registrar of the Judiciary. You also applied to become the Director, Human Resource. You also put in an application to be a judge in the Court of Appeal. Is there another pending application to join a tribunal?
Yes, my lady.
Which tribunal is this?
Competition.
The Competition Tribunal. That application is still yet to be processed. Is that correct?
I never got any response, so I assumed I was not shortlisted.
All right, maybe I can tell you that it is yet to be processed and it is pending. So given these various applications that you've made, could you walk us through your interest in these positions and how you assessed your fit for each of those positions? We'll begin with the Deputy Chief Registrar of the Judiciary.
Thank you, my lady. Those are not the only times I've applied to judiciary. When I finished university, before joining the public service, I tried judiciary. But the interviews came almost the same time, so I was told, you've just joined public service, you can't join judiciary. I've always desired to serve in the judiciary so that I can contribute to the development of the law in this country. The Deputy Chief Registrar is because basically I believe that's a role that is administrative in nature and handles the human resource for the judiciary. I'm a human resource practitioner, I'm a lawyer, so I believed I would fit within that system, and it would give me an entry point to judiciary, where then I would understand how judiciary administration structures work. And being a lawyer, I would work in an environment where a majority of the people really are lawyers, judicial officers. But my experience in HR and administration would help me strengthen the structures. At that point, judiciary was still taking a lot of transformational initiatives. So I believed having participated in transformational journeys at the Standard and at Faulu, I believed I had valuable experience that I would bring to that journey as judiciary was trying to put in place its own structures.
Very well, Mrs. Makori. I suppose that what you're telling us about the position of a deputy CRJ would also apply when it comes to the position of the Director, Human Resource.
Yes, my lady.
All right. What about the application in the tribunal? How did you assess your fit into that tribunal?
I looked at the requirements. Basically, they needed somebody who is a lawyer, basic understanding of the law. Though I've not worked in the competition authority, I believe implementation of the law, if you have basic understanding, you can work in any environment. A tribunal, other judiciary really is an entity that also contributes to development of decision making. It would give me the same opportunity that I've been seeking all my life, to participate in developing the laws, making decisions that could form precedents, and an opportunity again to serve within the judiciary.
So assuming that all these positions were available.
Yes, my lady.
Including the position of the Supreme Court, and the Judicial Service Commission is saying, make your pick. Which one would you pick?
Certainly I would pick the Supreme Court judge.
Because it's more prestigious?
Yes, but also it has a unique role, that of defending the Constitution, developing jurisprudence in new areas, supporting the lower courts in clarifying the legal position. Having worked in IPOA, I appreciate the role of constitutional safeguards.
All right.
So I would be a defender and a promoter of the Kenyan Constitution, because I know the delicate balance that requires to be played in protecting individual rights and the space that I worked.
All right.
State authority.
I can't fault you. If I was also asked to pick which one, whether the tribunal or the Supreme Court, I think I would go for the Supreme Court.
Thank you, my
Now,
lady.
one or two technical questions from me. You've very well articulated the jurisdiction of the Supreme Court.
Yes, my lady.
Which jurisdiction of the Supreme Court has not yet been exercised by that court?
Hearing and determining an application on state of emergency.
That is correct. Applications emanating from a declaration of a state of emergency. Secondly,
Yes, my
is
lady.
there an instance, or are there instances when the Supreme Court acts as the first appellate court?
Yes, my lady. Under Article 163(4)(a), as an appellate court.
Is there an instance, or are there instances when the Supreme Court acts as the first appellate court? You understand about the first appellate court?
Yes, the first appellate court is the Court of Appeal or the High Court. So when it has had
Or maybe to put it in another way, is there a time under the law that the Supreme Court, there is provision in the law that it can act as a first appellate court?
Yes.
Please tell us.
In hearing applications from the tribunal on disciplinary matters for judges. If the judge is aggrieved by the decision of a tribunal, then he appeals to the Supreme Court.
So what then is the role of the Supreme Court when it is hearing appeals from the tribunal?
The past decisions that the Supreme Court has looked at, the first thing the court determined is that the judge has the right to appeal and to benefit under Article 47 on fair administrative justice, and that the court can actually look at the decision of the tribunal and determine the merits of misconduct, whether the threshold on misconduct was met, and can uphold that decision or vary it.
So it reassesses and reevaluates the evidence.
Yes.
Thank
Yes,
you,
my
Honorable
lady.
Chief Justice. That's all from me. Thank you.
Thank you, CJ. Council,
Yes, Honorable Mwanza.
yes, before 2010, the highest court in the land in Kenya was the Court of Appeal.
Yes.
Then there was clamor for 2010 that Kenyans now reimagined their new order
Yes.
and came up with the 2010 Constitution. Now, if you read the CKRC report, you'd see that there was an original intent by Kenyans of establishing the Supreme Court. The CKRC report has, in fact, summarizes what it says are arguments that were clear and convincing for establishing this court. Perhaps you can tell us 4 of those that were presented as the basis of establishing the Supreme Court.
Thank you, Honorable Mwanza. Before the 2010 Constitution, the Constitution that existed did not have the participation of the people. And therefore, the Constitution that we have, we can say is the Constitution that affirms the sovereignty of the people of Kenya.
Yes.
And therefore, there was need to safeguard the interests of Kenyans in ensuring that Constitution is protected, is interpreted, is...
Council, I want you to be direct in answer. So there was actually a reason why Kenyans said they wanted the Supreme Court established, and that is found in the CKRC report. The CKRC report summarizes the original intent, and in that report it says these are the clear and convincing reasons of why we established or we are establishing the Supreme Court. Did you have occasion to read the CKRC report on why Kenyans intended to establish the Supreme Court?
I have not read it recently, but I know Kenyans needed the human rights aspect entrenched in the Constitution.
No, there is a specific reason that is captured by the Committee of Experts and also in the CKRC report. It's a very clear intention, and that forms the basis of establishing the Supreme Court. If you cannot recall, we can go
backwards.
Yeah.
And I know one of the areas that required attention is the reforming of the institutions.
Let me ask you a direct question. Have you had occasion to read the CKRC report or the Committee of Experts report on why there was an intent to establish the Supreme Court?
Not in an academic sense.
Not academic, it's just a report. Okay, let me go to another area. Now, under Article 163B of the Constitution.
163, 3B.
Yes, 3B, yeah? It stipulates that the Supreme Court shall exercise appellate jurisdiction and here determine matters from 1, the Court of Appeal, and 2, any other court or tribunal established by national legislation. Now, which other court, other than the Court of Appeal, does Article 163B2 of the Constitution contemplate? That's the first question. The second question is as follows. Considering the decision of the Supreme Court in the case of Macharia versus Kenya Commercial Bank on a special jurisdiction of the Supreme Court under the Supreme Court Act that was declared unconstitutional, does Article 163B2 contemplate an appeal from the High Court or such other superior court other than the Court of Appeal? And lastly, can you specify instances whereby it could be appropriate for national legislation under Article 163(b)(2) to provide for a leapfrog appeal to the Supreme Court, on an assumption that such appeal is sanctioned by the law?
On 163(3)(b), I believe the reason the Constitution specifically says is prescribed by specific registration is because appeals lie to other courts. An appeal from a tribunal can go to High Court.
No, that's a very specific question. If you look at 163(3)(b), you have the Constitution before you.
Yes.
So that we don't discuss generalities. 163(3)(b), Roman 2. Now, before I again ask that question, have you had occasion to read the case of Mashari and another versus the Kenya Commercial Bank on the special jurisdiction of the Supreme Court? This is a determination that was made by the Supreme Court.
I know the decision on SK Masharia where the court said it cannot allocate itself jurisdiction.
Okay.
And that was because in that particular appeal, the Supreme Court felt the law did not give it the jurisdiction. Although we know there are other matters, and I don't want to go into that, where the court, based on the constitutional nature of issues, have determined that it has jurisdiction in specific cases.
Okay, let me ask another question. Now, if you look at 163(4).
Yes.
It provides that appeals shall lie from the Court of Appeal to the Supreme Court, as of right in any case involving the interpretation and application of this Constitution.
Yes.
Okay.
Yes.
In your view, are those words synonymous, interpretation or application, or are they separate? And what would be interpreting or interpretation of the Constitution, and to application?
The first one is to interpret, is to look at the actual meaning of what the crafters of the law intended. So you interpret what the law intended to achieve. Application is in what circumstances then can that law be applied.
So are those separate jurisdictions under that A?
No, they cannot be separate, because once you interpret, then you determine the circumstances under which that law then can be applied.
So can, for instance, an issue arise to the Supreme Court on application of the Constitution that does not involve interpretation?
Application without interpretation.
Yes.
Yes, I think an issue can arise.
If you can give an example.
On application. Application. The one I can think of, there is a very recent case. Where the decision of High Court I would call it in structural interdict, Okia Umtata case, and I think that was the decision of Justice Mrima, who is seated here. The High Court had followed the decision in Mitubel and decided that Parliament had unduly delayed passing the law that would then transition tribunals to be under the judiciary. And the High Court held that there was an due and reasonably delay in line with Article 259(8). And the Court of Appeal agreed with that decision. But the Supreme Court said there was another aspect that should have been looked at, the intent, the intention and the desire, the intention to implement. So I think in that particular matter, the issue was not application. It was not interpretation of what the existing law is, but whether then structural interdict can apply in the circumstances under which that application came.
So is this provision applied in either or?
Can be in either where the issue of interpretation is not in question, but can also be both.
Okay.
Yes.
Now, lastly, I want to ask about a statement that is made about the court, that this is a political court. Would you agree with that statement, that the Supreme Court is a political court? And if you do, what would that imply?
Within the Vision 2030, we have different pillars.
Not Vision 2030. We are discussing the Constitution. Is it a political court or not? And if it is a political court, what does that mean?
I wouldn't call Supreme Court a political court. It only has mandate that exposes it to unique political situations. That is of interpreting the Constitution, safeguarding the rights of Kenyans, safeguarding the law. And in that regard then, there will always be issues that touch on legal interpretation, the rights of the people, and a lot of those rights usually are where they are not observed or where they are violated. And
in providing leadership in terms of issues that transcend the interest of the parties, infusing values, new values about the Constitution, and perhaps streamlining case law, and sometimes even making choices that are unpopular.
Yes.
Or against even, say the executive. Would you say then, is it a political vote or is it not?
I don't think it's a political court. It's a court that has a mandate that touches on separation of powers.
Okay. I know.
Because if we call it political, then how will Kenyans feel when they are coming to a political court? They have the confidence that wouldn't it give the connotation that it's always fighting, it's always causing?
No. You are sitting at a very high table where you will be among 7 people if you are nominated to determine what the law says with finality.
Yes.
So you cannot sit on the fence. We must hear you so that when you're assessing you in 360, we know where you stand on certain issues.
I don't think it's a political court.
Okay, lastly, let me just ask this. I said that was the last, but having had what you've done for the last 30 years.
Yes.
Okay? Would I be correct to say that you've, 80% of your time focus on human resource and management?
with a lot of respect, that's not a correct position.
Okay. Did you, if you look at where your specialty is, even from your own submitted sample writings, you seem to have focused a lot on human resource. Is that true or not?
That's true, but human resource is also a branch of law.
Okay.
The labor laws.
So let me follow up with that. Secondly, if again I look at your sample writings, they seem to suggest that in terms of interaction with the court, because you've submitted sample writings with respect to to a matter you did in ELC. Okay? Mm-hmm. So have you had occasion, for instance, as an advocate, to appear before the Court of Appeal?
Physically, no, but I've had several matters at the High Court.
Okay. In the Court of Appeal or the Supreme Court?
The Supreme Court, certainly no.
In the Court of Appeal?
No, not yet.
Okay. Then, now trying to locate your experience as somebody who wants to sit and make a final determination on what the law is. Actually, it's a position of stewardship that you are given by Kenyans to say when we are disputing about what the law is, whatever the 7 of you say, we will accept it. Is that true or not?
That's true. Kenyans have to comply with, with the Supreme Court.
Locating and tracing your life history for the last 30 years, would you say that you are the person and you have the experience for this high calling?
Yes, I do. In fact, I'm the best placed because my experience spans several sectors, and not forgetting I've had the opportunity to lead a national entity.
No, I understand that, but now we are discussing the law. Now, in terms of, have you sat before in any tribunal as an appellate judge or in an appellate capacity?
I've appeared before High Court representing a client in an appellate matter.
In the High Court?
Yes.
But as you've said, you've not appeared in the Court of Appeal or the Supreme Court?
Yes, I haven't.
Okay. That's all, CJ.
Maybe my lady, to answer Honorable Mwanza, we are all lawyers, different exposures, and I think different capability to interpret and apply the law. Only that we've worked in different sectors, applying different sets of laws, but law is law. And I'll not be sitting alone. I'll be sitting in a college of judges. So where I may have gaps, I believe I'll have the opportunity to learn, and I'm a quick learner.
Very well. We'll move on to the Honorable Attorney General.
Yes, good morning, Anne.
Good morning, Honorable Attorney General.
A famous advocate by the name Oliver Wendell, who died in 1935, was a jurist and associate justice of the Supreme Court of the United States of America. So he once said that the life of the law has not been logic, it is experience. What is your take?
That's very true. The best way to learn the law is experience, exposure to different aspects of it, opportunity to engage with it from wherever you are, whether it's academia, whether it's practice, whether it's the bench. If you just read law and sit at home, certainly you'll get rusty. So I believe that's true, and that's why we seek to keep practicing and keep reading.
So what is that special attribute or experience that you think will bring to this court to complement the expertise that is already there?
Thank you, Honorable.
Unique.
The unique experience that I have is that as I approach judiciary, I do so with a lot of governance experience. And therefore, I'll be bringing an all-rounded legal practitioner with experience in practice, public service, private sector, commercial sector, corporate, human resource, and therefore a lawyer who is molded through accountability.
Can we house that experience in a particular branch of law that is within the jurisdiction of the Supreme Court?
Mainly in civil litigation and commercial. Commercial division and commercial division mainly.
Thank you so much, Honorable Chief Justice and Wakili. Once again, welcome. A very short discussion from my first is sitting as a judge in any court, be it at the first level of the superior courts, or the appellate COA, or the Supreme. Whenever a judge is applying, rating the Constitution, it is imperative for the judge to understand the historical background of the issue at hand. Why do you think that is important?
Thank you, my Lord. It is important to understand the historical background because it raises the basis of the legal issues that need determination. Without a proper understanding of the background, the judge may not understand what the parties before him or her is seeking to achieve. So it's important to understand the background of every dispute that comes before the judge.
Background of the dispute, say, I'm referring to the understanding of the historical background, that provision of the Constitution, not of the case before you.
Yeah, okay, thank you. Yeah, it's important to understand the historical background of the provision or the law being applied so that then the judge can be able to effectively meet the aspirations of the people that have come to seek justice, and also to ensure the legal provisions being applied are the right ones and can be defended.
Okay. Does that have anything to do with the transformative nature of the Constitution?
Yes, it does, and the transformative nature of the law, really. It's ever developing. The Constitution is, particularly the Supreme Court, is always being confronted with unique issues that have not been determined before. So it has to sort of give pioneering guidance.
Okay, we may hold it at that. And just something on elections, and let's go to the issue of validity of votes. And on this issue of validity, I want us to narrow it down to one of the jurisdictions of the Supreme Court on elections, which is the presidential election. If we run through Article Constitution, this is what a candidate shall be president if the candidate receives more than half of all the votes cast in the election. More than half of all the votes cast in the election. Council, you understand the meaning of the word casting?
Yes, voting.
What is to cast?
Voting.
Yes. You receive staff, you fold it, you put it in the ballot box.
Yes, my lord.
That's casting.
Yes.
If we look at this article, 138.4a, which plainly states that the candidate, which says that the candidate will stand elected if he gets more than half of all the votes cast. And with our understanding of what casting is, does the term votes cast as used in the Constitution, plainly used in the Constitution, include rejected votes?
Rejected votes, my lord, are never counted as valid votes. So I believe 50+1 means the properly marked votes that are not in doubt.
Council, sorry, Council, we are looking at the Constitution. The Constitution says votes cast. You are introducing an element of validity. You are saying valid votes cast. That is not in this provision. This provision only says votes cast. Are you bringing the issue of validity by virtue of interpretation, or maybe you are relying on a certain decision somewhere?
No, my lord. The reason I've said the properly marked votes is because rejected votes don't go into determining the candidate because they are wrong in the first place. They are invalid. So you cannot validate that which is invalid right from the beginning. We can't tell who they intended, those people intended to vote as a president. So we can only determine 50+1 of the valid votes.
You're right. We cannot include rejected votes in the count for who is to be declared as the president. If you go down to statutes and subsidiary legislation on that aspect, you will come across Regulation 69, Subregulation 2 of the Election General Regulations 2012, which now deals with the issue of valid votes cast. Valid votes cast. The issue of validity is now introduced by subsidiary legislation. Now, could you be aware whether the issue of validity of votes cast was dealt with in Raila 1, 2013 and Raila 2, 2017? Was it one of the issues in these petitions?
I'm not very sure whether it was one of the issues, but I know the main section that was due for determination was Section 83 of the Elections Act that dealt with the issue of transmission and whether if the flows with a non-compliance with procedures and the law would affect the number of. You need to show that it affected the final results. So essentially, we would say probably yes, by virtue of looking at whether the processes affected the final vote.
So was it an issue or was it not in both or any?
The issue of number of votes was an issue, but in both petitions, I think the focus was mainly on Section 83 of the Elections Act.
Okay, and maybe we can leave that discussion there. And just to wrap it up, I just want to go back to the issue of the votes cast and the valid vote cast. If you look at the two provisions which I've referred you to, the word vote cast is used in the Constitution, and the word valid vote cast appears in the subsidiary legislation. Now, how would you justify using subsidiary legislation to limit the plain meaning of a constitutional provision? How does it come in?
Thank you, my Lord. My understanding of subsidiary legislation is that it operationalizes, so that it breaks down the main constitutional provisions. So the subsidiary legislation intent is to operationalize the constitutional provision, give it clarity, give it explanation. So I wouldn't say that the subsidiary legislation is invalidating the Constitution, but bringing clarity to the constitutional provision by guiding whoever may want to use that law on how to operationalize the particular constitutional provision.
That is by applying the purposive interpretation to give meaning to the Constitution.
Yes.
Thank you very much, and I wish you the best.
Thank
That's all, Honorable Chair.
Thank you, Chair. Good morning once again, Council.
Good morning, Madam Ngutia.
I saw you taking water, but if you need more time, you're allowed to do that. Thank you. Council, you did share with us 5 sample writings, and there were submissions before the ELC and Chief Magistrate Court. You also shared a newspaper article and a human resources manual that you prepared. I did take note that the submissions from the Chief Magistrate Court are dated 9th July 2021 at a time when you are a chairperson of IPOA. So I just needed you to clarify whether you were the author or you were allowed to practice while the same time being a chairperson at IPOA.
Thank you for that observation. As the chair of IPOA, I was not really in very active practice. That's a matter that had started when I was still in practice in 2018. But again, I don't think there's anything that specifically would prohibit me from doing that, because I was not getting non-practice allowance. We were never paid non-practice allowance. It's an issue that was discussed at length.
Okay, I just needed to confirm whether you were the author, because at that time you were not, you were at IPOA. And again, the newspaper article and the human resources manual, we are not able to assess your adjudicative writing skills, especially when it comes to legal analysis. There is limited engagement with contemporary legal disputes, minimal application of legal principles. So again, you want to join the Supreme Court and you have submitted to us those 2 sample writings. Again, I needed to get your view on why you chose to submit those 2.
The reason I chose to submit those 2, Honorable Chair, is because I believe the writings are meant to show the capability, written skills capability of the judicial officer. And judicial officer writing capabilities, while most of the writings will probably in writing judgments, ruling, and court-related advisories, writing skills are not only determined by writing judgments, it shows appreciation of other contemporary issues and understanding of other areas of law that may not necessarily be judicial writings. And I believe it's important that a judicial officer should be able to engage with a wide range of issues, while the main job is judicial writings, judgments, rulings. It's also important to understand other contemporary issues.
Okay, you have been making reference to that position as a judicial officer, but I'll leave it at that. But it's not a judicial officer role, it's a judge of the Supreme Court role. Though there are the submissions, you identify issue clearly, but I take note that they do not advance any new issues. So your contribution to jurisprudence, I can't really tell from what you submitted. Fair enough, I'll take you through a question that I had.
Maybe if you may allow, Chair, I think I submitted a writing on employment and labor relations matter.
Yes.
Constructive dismissal.
Which is okay. What I'm just saying is that they do not advance a new area. Constructive dismissal are issues that have been litigated before courts, so there was no growth of jurisprudence. You just restated what courts have declared over the years.
I've given that particular case a basis in the Constitution, Article 41. So my dream was it would go on to Supreme Court, and Supreme Court can have the opportunity to address the issue of, depending on the decision, on constructive dismissal. So yes, basically that's why I was anchoring it on the Constitution.
Okay, sorry for that. But you agree with me that this is not a
new area.
Okay.
Yes.
Thank you.
Because of the nature of the case.
Okay. So according to the World Bank and the African Development Bank, secure land rights in Africa are important because they unlock economic potential, they secure rural livelihoods, and they are a driver for investment. Do you agree with that statement?
Yes.
And I know when you're preparing for this matter, you had an opportunity to go through the Dina Management Limited versus the county government of Mombasa matter.
Yes.
Where, in essence, the decision challenged the torrent system, and in essence, we cannot really trust documents from the government institutions. So it's not enough to just say, I am a bona fide purchaser for value. You need to go deep to the root of title.
Yes.
So looking at that decision, whereas it's commendable because it has really brought to the fore the land question in Kenya, but some critics argue that it created uncertainty because the Supreme Court, the decision failed to define the scope of the due diligence expected for purchasers, investors, and developers, potentially exposing land transactions to abuse and endless litigation. I don't know whether you agree with that statement or not.
Not entirely.
Not entirely. Okay. And again, the critics also argue that the cost of institutional failures is then passed to innocent purchasers, hence weakening the constitutional guarantees of secure property rights. So this is a decision that has far-reaching consequences in the land sector in Kenya. So how should the Supreme Court balance the duty to invalidate illegally acquired title with the need to promote certainty and confidence in the land market? That is part one of that question. And would it be necessary for the Supreme Court to develop guidelines to clarify the doctrine of root of title so that we know how far should one go, how wide should one go, and whether the credibility of that village drunkard should be considered. And at the same time, hold state agencies accountable for their records.
The first question is on Supreme Court. What Supreme Court, how the Supreme Court can ensure sanctity of title. Looking at that decision and looking at the background of land law, under the common law, it was a requirement that you should look at the background of the title. The Torrance principles only came in to try and simplify the process of registration and present the title as a shield. I don't think the Supreme Court would have a problem in making decisions that touch on those aspects, because what is illegal cannot be validated by passing it to an innocent buyer. An illegality is an illegality. And therefore, if a title is acquired through illegality or fraud, it's a bad title. And that, I think, was the underlying principle in Dina and Torino. You cannot pass that which you do not have. And I think in law there is also the general principle of caveat emptor, buyer beware. I don't think the law has changed that. It's important that buyer beware what you're buying, bearing in mind you cannot pass that which you do not have. So I think that decision brings clarity to many things. First of all, how to handle public land. Public land is not meant for private use. It should be protected. If land is meant for road, reserve, public utility, it should be protected. I don't think Supreme Court would be conflicted in any way in making that determination. And therefore, it protects public land from, in quotes, being grabbed. It clarifies the law that if a title, the origin of the title is illegal, title in itself is not a final shield. The title cannot shield that which is illegal.
Okay, maybe
so I think the Supreme Court, I don't think would have a problem in making those determinations. However, in terms of the tolerance principles and the sanctity of title, I think the agencies that are responsible for ensuring what is in the registry is accurate should be held to account. There should be accountability. And probably mechanisms for compensating people who suffer, having relied on the information that is held by the agencies that are deemed to have the correct information.
If I could maybe just take you back in terms of the after effect of the decision. Critics say it has created commercial uncertainty and reduced the confidence in land market within our country. So people are not buying land. Investors are scared of investing in Kenya when it comes to issues around land, because they do not know how far they should go when you're told, go to the root of title. So is it necessary then for the Supreme Court to have developed guidelines on how far, or we just leave it at that? Or should it be on a case-to-case basis? Just your thoughts on it.
My thoughts on it is that probably this is a matter that should go to NCAJ. And involving NCAJ brings together, I had the opportunity to sit as a council member of NCAJ when I was representing my institution. NCAJ develops a high-level policy, and all critical stakeholders sit in as members of NCAJ. It's probably an area we should ask NCAJ to look at using the technical capabilities and the benefit they have of having access to a wide range of stakeholders that sit there and expertise, maybe develop a policy that can be considered for adoption and to guide the courts going forward.
Okay, thank you.
Thank you.
Chair.
Thank you. Let me take you to the presidential election petition process before the Supreme Court. Am I correct that you earlier said that you are aware that the Supreme Court has dealt with 3 petitions of that sort? Is that what you said?
Pardon, the Supreme Court has dealt with?
How many presidential petitions?
3.
In which year?
2013, 2017, and 2022.
You're sure there were only 3?
There was one that challenged the presidential election 4 after the repeat election in 2017.
So there were 4 petitions.
There are 4. Yeah.
Okay. If you are to, I want us to look at the timeline for a presidential election petition. So once a declaration is made by the IEBC, a petitioner is to file a petition within 7 days to the Supreme Court.
Yes.
Do those 7 days exclude weekends and public holidays?
Article 40, a person may file a petition in Supreme Court to challenge the election of president within 7 days after the date of declaration of results of the presidential election. The law does not specify.
No, the law does not specify.
The law does not specify. I think that's a matter for then the Supreme Court to determine how to interpret it.
Okay.
But if I were to be asked as a person, at a personal level, I would exclude weekends because the court does not sit on weekends.
Okay. Anyway, there's a very strict timeline, and the law does say within the Constitution, not in the article you're talking about, but the law does say. If once a petitioner files the petition, the Supreme Court must hear the matter within 14 days. 14 days from filing of the petition.
Yes, my lady.
What happens if there are multiple petitions filed on different days? So when does time start running?
I've not had the benefit to look at that, but if I were to sit in a place where that decision needs to be made, I think time should start running after the filing of the final petition, as long as it's filed within, you see, there is 7 days. So within, I think 14 days start running after the 7 days. 7 days, the first 7 days. So from there, then no petitions should come after the 7 days, and the Supreme Court can take over from there and continue with its work.
Okay. What grounds should the petition contain? What are the grounds for a petition? Seeking to invalidate the declaration, but on what grounds?
I think previously the courts have looked at the process, whether the process was right. Section 83 of the Elections Act says even if the process probably was not totally complied with, you need to show the results were affected. So I think you'd be looking at the process and the final outcome, the results.
Okay.
So both process and the votes.
Okay. Okay, so just to guide you, the grounds are contained in the Supreme Court presidential election rules.
Okay.
So I was hoping that you would have read them so that I'm able to examine you on them. Who is the respondent in a presidential election petition?
Who is?
The respondent. Who is the petitioner serving?
The respondent is the IEBC.
Okay. And how many days, what is the timeline for serving the respondent? No, you won't find it in the Constitution. So the respondent actually is the president-elect. It's not the IEBC. I'm just informing you.
The president, the president-elect, sorry.
Yes. Okay, once the Supreme Court has listened to all the parties, it can make a conclusion. What possible orders can the Supreme Court give?
I can rely on what the Supreme Court has done in the past. It can say the election was valid.
Mm-hmm.
It can invalidate the results and order a repeat of the election within 60 days. I think those are the two key.
What would the Supreme Court, in terms of a repeat election, what would the Supreme Court be ordering? Is it ordering for a runoff or for a fresh election, or what is it called?
The law says repeat. So I think it's all the candidates to determine whether they want to participate.
Is there a difference between a fresh election and a runoff?
Yes. A repeat is open to all the candidates. Runoff is where you have two top candidates, then they will go just the two contending parties, if the top two.
Yeah, so is it the Supreme Court who can order for a runoff?
Must admit, I'm not sure, but I know they can order a repeat election.
Okay. Finally, when is a petition, a presidential election petition, when is the petition deemed as filed? What are the requirements so that you say the petition has been properly filed?
Thank you, my lady. I think when you file the petition and all the supporting documentation.
And what else?
And served.
No? In the registry of the Supreme Court, when is a petition filed? When? When can you say the petition has been filed? When it has done, what steps have been taken by the party?
When filing a matter in court, you prepare the paperwork and then you pay.
Yeah, how much?
I don't know how much you pay for petitions, but I know you pay at least $1 million for presidential election as a safeguard to costs.
Yes.
But for filing the petition, I'm not sure. I've tried to find out how much they pay for the petition.
Okay. What if you file a petition today, the last day, and you forget something? You forget the affidavit of one of your witnesses. Can you file the affidavit the next day?
If you have filed the papers, all the papers are in the system, and the final day has gone, the only way you can file any other extra paper is through the leave of court. You cannot file without leave of court.
Okay. Thank you very much. Those are all my questions.
Thank you, Chair. Good morning once again.
Good morning, Your Honor.
Yes, I was going through your CV, and just as my brother Commissioner Mwanza, I got the feeling, just reading your CV, that your strength is mostly in HR. Though I had your response in respect to that question, so I'll not belabor that issue. But I wanted to engage you. You mentioned a national entity which you headed. I presume this is IPOA?
Yeah, Independent Policing Oversight Authority.
Okay. So what is the mandate of IPOA?
The mandate of IPOA is anchored on Article 244 of the Constitution. Mm-hmm. That article does not talk of IPOA. It places the responsibility on the National Police Service to do specific things. One, to professionalize, to enhance discipline while carrying out their functions.
Is that the National Police Service or
the National Police Service?
No, I'm specific to IPOA.
Yes, that's what I want to explain. Mm-hmm. To train, to observe human rights, and to operate in a manner that is transparent. Now, the National Police Service cannot oversight itself to do those things. So IPOA is established under the IPOA Act, Cap 86 of the laws of Kenya, that operationalizes Article 244 to oversight the police in regards to the functions of the police that are anchored in Article 244. So the mandate of IPOA is to oversight the police in performance of their functions, to support the police in ensuring that they comply with human rights standards, discipline, and of course, if there is offenses that are committed, to investigate those offenses, to monitor their operations, to just ensure they do their work within the parameters of Article 244, to inspect.
Okay, in a nutshell, we can say
in a nutshell, we can say the work of IPOA is to oversight the police in the performance of their functions, to investigate any criminal acts, to monitor, and to inspect.
Okay, okay. So generally out here, the feeling amongst Kenyans, you see, an institution is said to perform depending on the effectiveness or impact of their service on the ground. So there's a feeling generally amongst Kenyans that IPOA was doing quite well and could really be felt, the services could really be felt at the beginning. But somewhere down the road, it went down. Now, I just want to give you an opportunity to highlight for us your achievements. I've gone through your CV, and I don't know if I'm the one who's looking at it in a narrow way, but I get the feeling where the rubber meets the road in terms of the IPOA mandate, there isn't much you've covered in your CV. I see here you are talking about developing a HR instrument, which is good and commendable.
That is for the entity, for internal, yes, not in regards to the police. In terms of the police, a lot was achieved. And allow me to mention, before Honorable AG became AG, she was in DPP. She was in the office of DPP, and we worked very closely together. One of the areas we were able to deal with is address the issue of backlog of cases. And we were able to reduce the backlog of cases from over 20,000. By the time I was leaving, we had closed over 12,000 cases, up from about 3,000. The matters before courts, when we joined, there were hardly 60. I left over 470 cases before courts. Some of the outstanding matters, like the Baby Pendo case, working very closely with the office of DPP, we were able to close on that matter and make progress. So we were able to do quite a lot in terms of pushing, because justice delayed is justice denied. Basically clearing the backlog ensuring that matters are closed within a short time, because even if you're not being prosecuted, you need to know that you've been exonerated so that we don't keep the file. So we're able to deal with the issue of backlog. In terms of supporting the police with reforms, the recommendation on unmanned vehicles is a recommendation of IPOA. The recommendation on housing is a recommendation of IPOA, and it has been implemented. The recommendation on authority to incur expenditure for OCSs, so that the OCSs can have the money to fuel the cars and to do the little things they need to do within the police station, is a recommendation of IPOA.
I'm assuming all this you're telling us is under your leadership.
Yes, yeah, those were implemented. They were implemented under my leadership. Some of them started with the first IPOA board, but the first board had a lot of challenges setting up. So a lot of things were left unfinished. So we came finished and oversaw the implementation. So I'm talking of those that were implemented while I was there.
Okay, the reason I'm asking is because you have a segment in your CV where you're talking about your achievements in IPOA, and none of that is captured here. So I'm just curious as to why you've done quite a bit from what you're presenting here, but why none of it is reported anywhere or captured even in your CV?
In my CV, I focused on my role as the chair for the institution. So what I did for the institution, among many other things, and also developed the regulations that were long outstanding.
Okay, the other thing I wanted to engage you on this morning, as you're aware, under Article 159, Sub-Article 2C, as an institution, we are called upon to promote ADR. And as an institution, we have what we call court-annexed mediation, basically a platform for mediators to work in partnership with courts to resolve cases. So there's a conversation that is very live currently amongst the legal practitioners. And since you are one, maybe you can share with us what that conversation is about in the area of court-annexed mediation.
Personally, I've not been shortlisted as a court-annexed mediator.
No, I'm not saying you're applying for. You see, we are examining you in very many areas.
Yes.
Okay. One of them is just to understand what your mandate is. The question of ADR is part of your mandate and your concern.
Yes.
If you're a Supreme Court judge, that's why I'm asking you this.
The issue of ADR, for me, I think it's an important area. Because even without going through the ADR per se, the way, court-annexed mediator there, we are always filing consent judgments, which is a way of, ADR.
There isn't much time. Let's just go back to the conversation that is live amongst legal practitioners on court-annexed mediation. You mentioned earlier that you do mediation, isn't it, in your introductory statement? So that's why I'm asking you this. What is the live conversation right now? Okay. You are able to remember? No. I can give it to you. So the discussion is around non-legal practitioners practicing as mediators. And I was just going through the streets of social media last night, and I want to read you a quote from one of the legal practitioners. He'll remain anonymous for purposes of our conversation. In the matter of court-annexed mediation, I refuse to appear before a mediator who is a layman to adjudicate a legal dispute in which I'm my client's last hope. What is your take on that statement?
Now I understand. The use of non-legal mediators, because mediation, unlike arbitration, is not meant to be legally complicated. It's one of the ways of ensuring that parties get an opportunity to access justice in an environment that does not make them feel limited. And that's why when you look at mediation, the key area that you look at is what are the underlying issues. You need to resolve the underlying issues, because many times the issues that bring people to court can actually be resolved if you identify the underlying issues. In legal practice, you deal with what are the legal issues here. What does the law say? You don't give parties an opportunity to bring those other issues that may not be legal but are important for them to be resolved so that you retain relationships. Because legal way is adversarial. So I think there is a place for mediation, and there is a place for people who are not legally, because the way you do the agreement is structured. You don't just go and do your agreement out there, is guided so that it captures the issues in a way that can help the court arrive at a well-reasoned decision ultimately. So I think there is a place for mediators, because they are not supposed to be legalistic or legalists. They are supposed to help the parties resolve their issues in an environment that enables to do that and retain relationships.
Yes. So I take it from your answer is, your take is that it's not really a valid concern.
It's probably a concern that is arising out of failure to understand the role of mediation.
Thank you.
Probably those who are complaining are not mediators, and it's high time they trained as mediators to understand the role of mediation.
Thank you. Thank you, my lady.
Thank you, and sorry for that. Thank you, Chair. Good morning once again, Council.
Good morning, Madam Caroline.
Now, if you were to identify any three significant challenges currently facing the Supreme Court of Kenya as an institution, what would they be, and what role would you play in addressing those challenges?
I believe one of the challenges that the court could be facing, just like many other government entities, is the challenge of adequate funding. And adequate funding affects access to justice. The Supreme Court is based here in Nairobi and has only two other sub-registries in Kisumu and Mombasa. I want to believe an ideal situation would be where it can get closer to the parties that may want to access its services, but to do that, it would require resources. The other challenge is, I think the Supreme Court has been misunderstood. I was looking at the report on the annual conference that it held to call for papers for people to come and say what the issues they have, because people have complained that even some of the decisions seem not to agree. This decision says this, and this decision says this, and Supreme Court has to keep on clarifying. So I think the other challenge probably is facing being the apex court and not being too old is the challenge of being well understood, including by lawyers. The other challenge could be that challenge of being seen as political, putting it in a very difficult situation where you have to balance accountability and independence, and make people believe that the decisions you make are not driven by other extrinsic consideration, especially on the political arena, where people want to decide the way from their lenses, and we all have different lenses. So it's still charting new waters, and I believe even as they continue to grow new jurisprudence, there is a place to somehow go out there and help people understand it.
Okay.
Of course, that would take resources again, but yeah.
Okay. While at IPOA, please tell us of a time you were faced with an ethical dilemma and how you went about it, and perhaps any lessons you learned from the experience.
I can say there are many issues, but let me focus on an internal one. The internal one was at one point the commissioners wanted to get rid of the CEO. And as the chair, other than being a lawyer, as it has been noted by Honorable Mwanza and probably the rest of you, I'm also HR. So I could see the commissioners are making a grave mistake. Because this is an administrative action under Article 47, you do not only look at the procedures, you look at the substantive aspects of the issue. And I felt that termination, when you look at it, procedurally may have looked okay, give notice, ask the CEO to explain, but substantively, we're making a mistake. So I stood my ground. It was difficult, but to resolve it, what we did was to seek the opinion of the Attorney General. It looked like I was fighting a lone battle at some point, and I told them before we make a mistake that could hold us accountable as individuals, and we are surcharged. If we lose this case, let's get the opinion of the Attorney General. And we were well guided, and we complied with that opinion. It was a really difficult period for two reasons. One, I looked like I was alone. Two, it was the formative stage where we needed to bond and enable ourselves to understand each other so that we can run the entity as one body of commissioners. So it was a very trying moment. You are new, and you need cohesion within your team. And it looked like that cohesion is drifting through your fingers, and you want to hold it. Yeah.
Any lessons learned?
Yes. It's always good when you're in doubt to seek an opinion. The Office of the AG, for example, exists to do that. But it has also taught us thereafter to bond and understand one another so that the relationship don't have to drift that far. We can discuss most of them in a more amiable manner.
Okay.
Yes.
All right. Finally, for me, I'm looking at the feedback we received from the public. As part of this recruitment process, we engage the public to get their views on the candidates that we are taking through the process. And there is a number of positive things they've said about you, but I will highlight three that I would like to get your views on. There are people who felt that you're domineering, and they said that you do not give a chance to consensus. They also picked your close political leanings, and they said this may hamper your role as a judge. And then others, and I guess these are from IPOA, said that while you were serving as chair IPOA, during recruitments, there were some irregularities, and they felt that you would forward names given by top political offices. And then this would mean that the ones that do not have godfathers did not have a chance at IPOA. Maybe you will tell us what you think about those comments from the public. And with this, maybe how you tell us how you'll maintain judicial impartiality when a legal question is before you and that has profound political implications.
Thank you. The first issue is the issue of domineering. It's wrong to do your own self-assessment, but I don't think I'm domineering. I'm probably firm. And there are a lot of people we've worked with here. We worked with ODPP, we worked very closely with public service. They would be able to tell really whether I'm domineering. But I know I'm firm because as a chair of an institution, if you fumble and you are not firm, a lot of things can go wrong. Running government entities is not a walk in the park. There are many areas you need to look at. And I believe even the issue of domineering could be coming from IPOA, because there are areas you don't see consensus. Areas of accountability, it's either you are accountable or you are not. Areas of prudent use of public resources, it's either you are accountable or not. And when you are leading an institution, you get into conflict with a lot of people, and if you put your foot down, they say you are domineering because you are not accommodating certain things. But I do not think I am, because if I was, I would not be able to establish the very good working relationship that I established, a lot of support that I got from other agencies to make the work of IPOA possible. And as a judge, you need the independence of mind, even when you work in collegiality with others. It's good sometimes to know what you're talking about and to have your facts right. Then, as you meet as a college of judges, you can look at each other and see how you make progress, but that does not, collegiality doesn't mean you don't have independence of mind or intellectual discipline. It's expected you should have that. Close political leanings, again, I would say no. I was heading an institution, it's a government entity, you work within government policy. Even when you're oversighting, you don't go outside of the government policy. And therefore, it's important that whatever you do be in line with the government agenda. And whether that is considered to be political leaning, I do not think so, because I did not participate in things that showed I was favoring one political side more than the other, or one political, not an active politician. But when you're serving government, you have to work within the government policy. And there are not too many ways about it. You can be doing your things and you're a government official. And every government has its agenda. You have to work within that agenda of the government. In terms of recruitments, I do not think there were any irregularities. The recruitment processes were open. They are subject to audit. The Auditor General audited those processes. We never got complaints on recruitments. Nobody came to audit and ask questions. And we did them openly. The documents are there for anybody who would want to audit. So I would want, if there were any irregularities, certainly, why wouldn't anybody then ask for an audit or the process to be audited to clarify? It's an open process, it's a government entity. Everything is in black and white. Yes, that would be my response to those issues. And even if you don't want to go to any other entity, go to JSC, let JSC come in, or CAJ to come and audit those issues, and they are open, and we can be guided. I think IPOA had a very, very well regional representation. It's a highly technical area where even in recruitments, you've got to be very careful with the kind of technical capabilities that you bring on board. And therefore, I never received any complaint while there. I've not received any that has followed me after leaving. I would want to believe that we worked within the parameters of our mandate.
Okay, fair enough. In the interest of time, maybe the last bit of the question on how you will maintain your judicial impartiality, especially when a legal question is before you and it has profound political implications.
Judiciary, especially at the Supreme Court, you are guided by the Constitution and the law. And therefore, whatever you do must be supported by the Constitution and the law. If peradventure I had any issue where I feel conflicted, I would let the other members of the court know and discuss it openly and decide the best approach to it. If after disclosing what I think is my fear, it's felt that I need to continue, then it's incumbent on my colleagues to ensure that whatever we do, they are conscious that I declared something. Otherwise, I would be guided by the Constitution, the law. I'm a very committed person to protecting the constitutional safeguards because I've worked in the space of human rights. I would want to see the values in Article 10, equality, equity, most of strong believer of devolution, being enforced. So I would strictly be guided by the law and the Constitution.
Thank you, and I wish you well. Thank you, Chair.
Thank you, Honorable Chair, and welcome again, Wakili Ann.
Thank you, Commissioner.
Good to see you again.
Good to see you too.
Now, in your introductory remarks, I heard you say that you are strong in governance, and that is what you will be bringing also to the basket in the judiciary. The judiciary plays a crucial role in promoting good governance and accountability among public institutions. Assuming you are a judge handling a case involving allegations that a senior government official violated constitutional principles of transparency, accountability, and public participation, how should you approach such a matter to ensure that justice is served while maintaining the balance between the judiciary and other arms of government?
Thank you. Certainly there is a need for separation of powers, but judiciary sits at a place where it has been given the responsibility of advising government entities. So if the matter then, most institutions have their own mechanisms of dealing with these issues, but if an issue came and it requires interpretation of maybe Chapter 6, then as the Supreme Court, I would use my expertise in ensuring that we give that interpretation, that guidance, while ensuring that the independence of these democratic institutions is not unnecessarily interfered with. It's a thin balance, and that's why I have absolute respect for judiciary, because they have to ensure resolution of disputes by guiding on what the law says, while ensuring that the democratic institutions are able to practice their mandate. So I would use that expertise to give that guidance, fully aware of the mandate of the institutions.
Now, my second question, the judiciary often faces challenges such as backlog, corruption allegations, either perceived or real, and delays in delivering of justice. Could you tell us, as a Supreme Court judge, what leadership strategies you would propose or promote to strengthen governance within the judiciary and improve transparency, accountability to the public, and efficiency?
On the issue of backlog, I am aware that we have, through the NCAJ, active case management policy. I would to the best of my ability, be guided by that. Would also try to enforce a non-adjournment policy, and if a matter has to be adjourned, then it has to be very well defended why it should be adjourned. So I would have a non-adjournment policy on those on matters, so that we can observe the timelines. That is at the Supreme Court. I know there are a lot of other initiatives that are being undertaken by judiciary. In terms of corruption, I think you've called it right. It's a perception. And to deal with that, again, I'm aware judiciary has done a lot to deal with that by ensuring internal processes are put in place, like employee protection units, and so on, implementing the guidelines that were developed by NCAJ. By the time I left, they had not been complete, but I'm happy to note now they are complete guidelines on anti-corruption. If it's matters that touch on an issue that touches either a judge or a judicial officer, then they should be fast-tracked. So in terms of governance, then I would support and be a champion of STARGE. And social transformation through access to justice is a 10-year plan that is implemented annually. And accountability reports are done every year through the State of Judiciary and Administration of Justice reports annually. So it's just to ensure that we continue informing the public, we continue being accountable, we continue actively ensuring that the access to justice interventions that need to enhance that are being implemented. And eventually, holding, like what judiciary has started, dialogue. I'm also happy to note they now have a spokesperson who can answer to a lot of those allegations. Otherwise, profiling judges and judicial officers as corrupt, I think, with a lot of respect, should be resisted because it's a perception. But then we should not close our eyes to it. We need to take action to ensure that the concerns that the public has, because again, justice affects the citizenry, addressed by sharing information and ensuring we understood what we do as judiciary.
Okay, thank you. I wish you all the best.
Thank you.
Good morning again.
Honorable Governor.
Hope you're not tired.
I need the job. So I'm ready to convince you
Thank
that
you.
I'm the right person.
Thank you. Now, how would you approach stakeholder engagement without compromising the impartiality and while maintaining the independence of the judiciary?
Stakeholder engagement is a very critical aspect. And under judiciary, there is a mechanism for stakeholder engagement. Under the NCAJ brings together all justice sector players. And therefore, within that framework, you can engage almost all the stakeholders within the justice sector. Another way is when the Supreme Court was celebrating 12 years, they called out for people to write, and it's another way of stakeholder engagement without compromising on the accountability and the status of the court. So there are many aspects of stakeholder engagement. You can do lectures, dialogues, and you can engage specific stakeholders through entities like NCJ that bring together both state and non-state actors, and you can reach a wide range of almost every sector that you want to reach within that framework.
Mm-hmm.
If it's parliament, again, there are ways of engaging with.
Okay. What role does the judiciary play in community development?
Judiciary plays a lot of roles in community development because ability to do businesses and, like we discussed earlier, even own property, access to justice drives community confidence. So the way, the speed with which the decisions are delivered, the accessibility, removing the complexities, ensuring issues that touch on commerce are speedily handled so that they don't hinder the economic well-being, the social aspects. And I'm aware that Article 43, judiciary has made some decisions in terms of ensuring that the social and economic aspects of the communities are protected. So through STARGE, social transformation through access to justice, removing technicalities, and ensuring justice is delivered speedily.
Okay, thank you. Wish you well. Thank you, Honorable CJ.
Thank you, Honorable Governor.
Thank you very much, Honorable Commissioners. Before you close, or before we close, you saw me going through your records, and yes, we sent you a letter where we requested you also to provide us with your declaration of wealth. I don't see it here. Well, what happened? You are a human resource practitioner. So I expected you to comply with the letter requesting you to supply us with the documents.
My apologies, Honorable CJ. I thought the ones I uploaded on the system are adequate. I have copies. I can supply them.
You have the letter inviting you for the interview?
The letter inviting me for the interview, I think it listed.
It specifically asked you to bring the declaration of wealth for the last 3 years. I've looked through your documents. I didn't see it.
I have the documents at home and I had attached them to the online application, but I can deliver them.
They are not even online. I've looked online. I cannot see.
They may have dropped. I have them, Honorable CJ.
I'm just wondering why you didn't provide.
Probably it was I assumed that the online ones came through and my apologies.
Okay.
My apologies.
Very
I can deliver them by close of day.
Very well. This brings us to...
Should I do that, Chair? And where do I deliver them?
I think we have just noted they are not here because we are finishing with you now, because you ought to have read your letter properly and complied. So I don't think there is any need to bring them after we are finished with you today. Yes. So what we are going to do is, before we close, we always also give our candidate an opportunity to address us.
Allow me, Honorable CJ and Chair, to take this opportunity to thank JSC for the opportunity. It's a privileged position. I feel honored. And I hope that I've persuaded the team well enough. Obviously, I'm finishing on an anticlimax, knowing that my documents did not come through because I honestly attached them to the online.
They are not even in your bundle.
I had copies are not there. I admit, and I looked at them, and then I said, but I forwarded these things online. But they're available. I've done wealth declaration. I'm a public officer. I still serve, not really, I still serve in the government at Moi University Council. And declaration is a requirement, and I'm totally compliant. And therefore, I do hope that I'll be found to be the right candidate, despite the wealth declaration. They're available within the government because we declare and submit, including last year, in November. So thank you very much, and it's such a privileged honor to be here.
Very well. We also thank you for availing yourself for this interview, and on behalf of the commissioners, we wish you well. We wish you success, and we always encourage our candidates to keep up their hope, serving Kenyans in whatever capacity that you are serving Kenyans. And you'll hear from us when we complete the process. You are now released. Have a good day.
Thank you, Honorable Chair.
You can take
Have
it
a good day too.
Yes. You can even carry the bottle of water with you.
This one, thank you.